everybody, to LearnBiz, the Growth Small Business Podcast. So today we're going to dive into some IP, intellectual property.
Yes.
And you're prepared.
Well, we both know it fairly well.
Oh, I'm just going to share anecdotal stories. Like you give so when you're listening to this or watching this, if you want to know the actual information, listen to Ethan. Hopefully, I can provide some. Honestly, all joking aside, we just went through a process where a company that I was working with got sued. For some, for some of this stuff, and so I'll share a little bit of how that process played out.
That would be interesting.
With a little bit of a hey, this is how you protect yourself. Because honestly, I'll say this, and then we'll let you get into the official notes here. But a lot of times when I'm consulting a business on IP, unfortunately, I think that there's more of an emphasis that needs to be placed on CYA or liability protection.
Oh, yes.
A lot of people look at it as a competitive advantage, and it can be, but it's really hard to have it be a competitive advantage. It more often ends up being that you're making sure that you're not infringing on someone else's intellectual property,
yes,
or that you know how to protect yourself when people come and file suit against you. And I've got some good stories to share with that. But let's get into kind of some fundamentals here, and
so
we'll kick it off.
Let's talk about the three big ones, and maybe you could argue there's a fourth big one. So copyrights, trademarks, and patents, and then the fourth one I would probably put it as trade secrets. Would be the fourth one in there, even though it's not discussed as much, even though it is significant when you get into food and recipes and some other.
I'm even going to go broader than that. I'm going to say every business that I've ever worked with has trade secrets. Some of them are very valuable.
Yeah.
And it's the way you train your employees. It's
true.
The SOPs
it could be
that
some
you
processes
have.
that you have.
And honestly, I know we're going to talk more about the specific IP, but I would say if you're ignoring trade secrets, you're ignoring a huge competitive advantage, regardless of industry.
I agree. You should at least look into it, and we'll touch on it today a little bit as we do that one. But so let's start with copyrights, because it's pretty straightforward. It's easy. Exactly.
The easy, cheap one.
So copyrights, essentially are just creative material, so music, artwork, poetry, things like that. But there's one in there that most people forget about that is becoming very significant today, and that is code.
Oh.
Yes.
Okay, I would have forgotten about that.
Yeah, so the actual creating of code is a copyright.
Okay, makes sense.
Yeah. Now, copyrights are nice because in theory, once it's created, it's copyrighted, right? I don't have any other legal obligations to do. However, we do suggest that you should take some other steps just to codify that it's your copyright.
Correct.
So that's where most people, and there's all kinds of stuff out there that, hey, if I write some music, then put it in an envelope and mail it to myself so it's stamped. But my argument is, look, there's just so many things to get away with it nowadays with digital technology and technology in general. It's really hard to think that if I create something with a copyright that someone may not knock it off or say they did it before me. And so it's just, there's a U.S. Copyright Office.
Yeah, mailing the letter to yourself is not official.
Right. You do have to prove that you were the original creator of the material. Mm-hmm. So you have to have something generally that is third-party, independent, time, date stamped, right?
U.S. Copyright Office is
right.
That's the gold standard. And it's cheap.
And it's cheap. It's $50-$60.
Yeah.
It's not that. It can be a little bit more, but for usually just a piece of of creative material, it's $50-$60. It's not that expensive. And so if you really think it's significant, and it's going to go somewhere, it's going to have some value, do that.
Now, can I, if I'm jumping ahead, you pull me back. But so copyright, the interesting thing about copyright, when you're submitting it to that office, you're just kind of protecting the work that you have.
Yes.
Most of what you have, do you need to protect it or not? And this is a common question. And the challenge here is, if it's worth something, you need to protect it, but you never know what something's going to be worth. Now, some things are pretty obvious. Yeah. If you produce an independent film and that independent film took you a year and a half to produce,
right,
you better copyright that. But if you are just going to do like a PowerPoint presentation, a training presentation, does it have value?
Maybe. If that's your profession, maybe.
And so some of my content I copyright, some of it I don't.
Yeah.
And I'm like, okay. And you got to look at, what are you going to do if someone, are you going to go after someone for copyright infringement? Or what if someone comes after you for copyright infringement? That's really how I like to look at it. I like to look at it as not, okay, am I going to copyright this or not? I'm going to say, am I going to protect this with my dollars? Am I going to hire an attorney to protect this?
That's right.
And if I'm not, then I don't know that I'm going to spend a lot of time copywriting stuff that I'm not willing to protect. Now, there is some value in putting a copyright just to say, hey, this is mine, to kind of shoo people away.
Well, and I think in the digital age, especially when you get into that software code, I really make a strong argument that if it's significant, I would get a copyright on it, just because there's so many people that are generating code nowadays that you want to be the one who gets the credit if it comes to. Normally the only area I've ever heard arguments about copyright has been in music. Every year I hear some artist that, oh, hey, a songwriter, they stole my lyrics and blah, blah, blah. At least once a year you hear that one. I'll say that I don't hear too much.
Okay, but you got to think about, music is naturally public, like I'm putting it out there, versus software is behind the scenes.
Yeah.
But yeah, I mean, there's a lot of thefts that happen. There's a lot of infringements that happen. And I distinguish between thefts and infringements. Theft to me is intentionally, I'm trying to steal this. Infringement is, hey, I'm just doing my thing and I'm stepping on your toes.
Right.
And maybe I'm aware of it, maybe I'm not. The big infringement today, AI.
So, yes.
All of the copyright, I listened to a fascinating podcast that talked about where artists are saying, wait a second, AI does not generate images. It takes images online and then it modifies them. Yeah. But without our images, AI doesn't work. I'm not getting paid for that, but yet I produced the foundation for AI to work with. And the other thing, I hadn't thought about code, but code was brought up because one of the main things that AI is doing is generating code.
That's right. Yeah, code. AI will literally generate code for you. But it's, this, I mean, it will generate music. It will generate poems. I mean, you don't have to be creative anymore.
And so this whole copyright issue,
it's unreal.
It's going to take a big turn in the near future because it's really hard to pin down, because AI doesn't care where it takes information from. It just takes information, and it's programmed to take, quote unquote, the best information.
Yes.
And so it's just going to grab. And, how do you prove that AI took my, foundational code to build upon, or my foundational image to build upon?
Yeah.
You're going to see a big change in the near future.
Yeah, I agree. All right, so let's bounce to trademarks now.
Okay.
So just brands and logos. A couple pieces about trademarks that I think most people don't know is that you do have to renew trademarks. So keep that in mind, that if you do file an official trademark, so you want your your company logo with the text and the colors and all that, and it's part of your branding and you want to protect it. You do have to frequently renew those, and more so because, look, businesses come and go, right?
Sure.
So that's the reason why, is if that business goes out, that logo really is insignificant anymore. You actually have to, anyway, so keep that in mind. It's still fairly inexpensive, a couple $100 to do a trademark. So if you have something significant, great, go ahead and brand it, protect it. But the one piece about trademarks, more than anything, just to remind people, you do need to renew those if you do one, because they do expire.
Yeah. Trademarks is interesting. I've seen a lot of small businesses that they love their logo. Man, when someone starts a new business, where should you start? With the financials. You should map out your cash flow. I don't care what if you're going to launch a new business, step 1, map out the cash flow. Step 2, figure out the product and service. Literally, it goes in that order. And what's the order that everyone does?
The logo,
the name. That's what they're just like, I'm a business. Why are you a business? Because I just got my URL. And there's so many URLs. Who cares? Yeah. And so I've worked with a lot of small businesses that they think that their brand, their logo is the next Nike swoosh. It's not. I'm sorry. And so if I'm looking at trademark, honestly, I more care about trademark infringement. There was a classic case of Apple. It was, Apple computers that everyone knows with, Macs and different things, massive company, right? Well, it was stated that the term Apple had to stay within the industry, and, because Apple is a very common word. And so you had all these other businesses that had Apple in their name or in their logo, but it was outside of the industry. Well, all of a sudden, when Apple went into doing iTunes, a decade ago, 15 years ago?
Yes.
I forget how long ago. But so they start doing iTunes. And there was a company, I believe their name was Apple Records in the UK. And so they went and sued for trademark infringement. And at first, and I apologize, I'm doing this off the top of my head.
I don't remember this story.
So I apologize if some of the facts are a little bit off, but the premise is there. I believe that in the lower courts, Apple Computers won because they said, well, no, it's a computer company versus a record company. And then I think that they took it to the higher courts, and the higher courts came back and said, well, wait a second. Yeah, it's a computer company, but now you're coming into the music industry.
That's right.
And so you are infringing upon them. And so Apple had to pay out to this smaller record company so that they could use their name Apple with iTunes. And so kind of an interesting example. And I think it points out a couple of things. One is, it only really matters when you get to a certain level, and most small businesses are not at that level. Yeah. If you think your name is unique, it's not. Just try and find your URL. Take your business name and try and find your URL with a .com. It won't be there, because someone else has already picked that name, so it's not that unique. But the other thing is just kind of be aware. Like take some time from occasionally and check a few things out, but personally, and maybe you advise differently, personally, I advise most small businesses not to get too hung up in trademarks.
I agree. I'm like, look, before you spend any money on a trademark, I'm fine if you have something you really like, but be in business and 5, 6, 7 years, make sure that you've worked out a lot of those kinks, make sure that you get the clientele that you're following. If your sales are hitting over $1 million in the first year or two, then okay, maybe we'll get a little bit serious sooner. Mm-hmm. But just like everything else in your business, as your business matures, then we'll deal with that one as well.
Yeah. Well, and I think about me. So I launched my business officially in 2014, if memory serves me. Oh, hey, it's my 10-year anniversary.
Hey, what do you know?
I'm on my third name and logo in 10 years, so I'm averaging that I hold it for about 3 years.
As you try to refine it, improve it, and make it represent what you want it to represent. Yeah, it's not uncommon.
And so that's where I could have dumped a ton of money into that. I'm like, no, I try and keep it. And it's interesting because I just got back from a couple live trainings, and they didn't actually know the name of my business. They knew my name. They did not know the name of my business. And I'm just like, it's all good. Yeah. It's been there for a month, so, we just rebranded.
You done licking your wounds?
Not yet.
Oh, goodness. Oh, great story.
Anyway, that's all I have on the trademark.
So, all right, let's jump to patents then. Patents are a little bit more complex. And don't forget, I want to talk just a minute about patent pending too, because there's a lot of misunderstanding about patent pending.
Yeah.
So I do want to touch on that one a little bit. So patents basically, if I come up with an invention, / sometimes they'll use the word discovery. I generally stick with inventions. Now there's two types of patents, a design and a utility. Mm-hmm. So you have to kind of be aware of what you're doing when you get into that. And there's some good information out there on the difference of the two. Patents, generally there's kind of a phase and steps that you go through as you go through it. So you'll have a filing. And I'm talking about if you do it yourself. If you work with an attorney, they'll kind of take the lead on all of that. If you use an attorney, I don't know of any attorneys that will do a patent for you for less than $10,000, and most are upwards of 15 to 20.
Yeah, I was going to say, I think you're even being conservative with those numbers. Yeah. I tell people a full-on patent starts at 20.
Yeah, if you use an attorney, if you're brave enough, and a lot of people do it themselves, so I don't discourage it.
I do. Go ahead. I want to hear your reasoning.
I don't. Because there's a lot of utility and design patents are pretty straightforward. The younger generation has grown up with technology to where they're drawing and documenting stuff online a little bit more. You can take AutoCAD classes if there's some mechanical type movement to it and stuff that you want to document. So I don't discourage someone from doing it themselves, but at the same time, I always say, look, there's a number of, you can go to the U.S. patent and search patents. Google Patents is another one you can search. So I would say research some patents, look to see what they're filing, make sure you can do and provide that documentation. Otherwise, your patent will be denied.
So this is where I'm coming from, right? And I got to kind of unpackage this a little bit because I'm gonna put some things into my reasoning why I'm saying I don't advise doing it yourself. So the first thing is I actually think that it's more important that you do a patent search for other people's patents than it is that you have your own patent 9 times out of 10.
Yes.
Okay. And the reason why is you don't want to invest a lot of money into some R&D and then find out that you can't do what you want to do. And so you got to be really solid if you're doing something that is really patentable. So I'm going to back up here and I'm going to kind of define what I mean by really patentable. If you take something and you just, go to the hardware store, buy a couple things that are off the shelf and, stick them together and then you're turning around and selling it, I'm not even going to go down the patent path.
That's right.
Because you did not engineer or develop or design anything. You took some off the shelf. So to me, that's the first threshold is I'm going to say, is there anything that has been custom designed? Because if all you're doing is taking other people's designs and combining it, I don't think that you're going to, it's possible that the combination is unique enough, but it's not likely. It's not likely if you went and bought some stuff online and then came back and, duct taped it together, and now you're doing a YouTube video to show how, look, you can make your own. I was watching a camp kitchen, a little sink for under $20. And I'm like, there's no patent in this because he's just showing how he bought a water bottle and he bought a pump and stuck them together, right? And so the first thing that I'm going to say is most businesses, unless you have a legit R&D, engineering, software development, something that is building and creating stuff, you probably aren't even going down this road.
Well, and I counsel people to be very careful because, I hear it. Well, I have a 3D printer. I can print all this, right? Okay, that's great. However, is your 3D printer going to be able to sustain commercial use, right? Can it not only in production of commercial in quantity, but the quality of it, is it going to be strong enough to do it? Now, on the other hand, there are some things that's interesting with 3D printing actually fall underneath a copyright, not actually patent stuff.
Right, the design.
Yeah. So anyways, if you have a 3D printer, be careful to think, hey, because I can print all this stuff that,
Well, and that's the thing. Are you designing it or are you purchasing or borrowing someone else's design? So going back to the original thing of why I say that I wouldn't try and do it myself is most stuff that I see small businesses trying to get a patent on, I really don't think it's worth getting the patent on. It's expensive to develop product.
And to that point, though, this is where I say I'm not opposed to someone trying to do it themselves, because if you are not sure whether you can get a patent or not, if you do the filing fee, it can be $300 to $900, depending on a couple variables.
Yeah.
So that's much cheaper for you to file that yourself than with an attorney to say, I can't, it won't make it or not, right?
And
they'll accept it or they won't accept it.
I'm okay with some soft steps. See, patent is interesting, and I assume you're going to get to this because unlike copyright or trademark, I kind of have stages of, so I start with a patent search and then I move to a patent pending and then I move to a full on patent. And even within that, there are stages of.
That's right.
And so, I can soft step it and say, okay, I'm going to hold my place. I'm going to put a few $100s down and hold my place on this. So that someone else isn't going to, steal it.
Right.
But
But if it's something legitimate, I don't disagree with you having a patent attorney, and I say a patent attorney, not an attorney, a patent attorney, okay, who specializes in it.
Yeah, no divorce attorneys.
Yes, that will take you through it. Could be wise, especially if there's some merit. So if I'm in a manufacturing organization, I already do some manufacturing and some stuff. We're creating something new. We have the ability to do it. I'm probably going to be serious about that patent.
So let me put one more threshold that I have. Personal standard, rule of thumb, don't hold me to this number, but I put a number down because I think it's good to have a framework. If you're not in a position to invest $50,000 or more toward the development of this product, patent is off the table. Yeah. So the reason why I put that there is I say there's a lot of people that think, oh, hey, I need to get this patent. I'm like, what good does a patent do you if you can't actually manufacture? And manufacturing is going to be more expensive than the patent.
Yeah, that's right.
And so if you can't make this go.
Well, and they fall into the same mistake that, well, hey, wait a minute, I'll get the design patent on it, and that way I can sell off the design. And I'm like, you don't understand that people are good enough with patent nowadays. They'll know how to get around that design to make something and just cut you out of the picture anyways.
And that's fascinating. So when I was in my MBA program at college, we actually did a section on patents. And they found that this study, now mind you, this was 15 years ago, so but it said that about 40% of patents are really unenforceable because it's so easy to find a workdon't with the design.
That's right. They're so generic.
And which is another argument that I'm saying, if you don't understand the ins and outs of patents, and you go ahead and get yourself set up with a patent, you got to understand how likely is it that someone's just going to do an easy workaround.
So let's talk about patent pending, because this is interesting, and it ties into this part of the conversation that you see all the time on products, patent pending, or you hear someone say, I have a patent pending. Here's the problem with patent pending. There's no legally enforceable things you can do with a patent pending. If someone knocks off your patent and does the exact same thing while you have a patent pending, there's nothing you can legally do because it's not a patent.
I did not know that.
Yes. There's nothing you can do.
Okay.
It's not legally enforced.
Enforceable, yeah.
Yeah. So that's where most people think, oh, I have this patent pending, I'm protected. And I'm like, no, you're not. Now, here's the crazy thing. Patent pending can last for 2 months to, a couple months to several years as they go through that process, depending on how complex the item that you're trying to get a patent on is. So the frustrating piece about that is, think about it. If I pick up a product and it has a patent pending from 1990, I'm not even stressed about whether I knock that one off, right? No. The patent, plus 20 years have gone by, but patent pendings, that's where you have to be really careful, not only from you, but when you see that, there's just no legally enforceable rules with a patent pending.
Okay, now correct me if I'm wrong. This is my understanding of patent pending. A patent pending holds your place in line that if you want to get the patent, you can get the patent.
Yes.
So if someone knocks you off and then you turn around and get the patent, it doesn't stop them from knocking you off. It now gives you the right to legally go after them.
Correct, because once the patent is awarded, it goes back to the filing date. So it's retroactive.
And the challenge, and this is where that $50,000, and if you want to put $100,000, whatever number you want to put there, but the reason why I'm saying, okay, don't even start this process if you don't have $50,000, because so you get knocked off. Now you've got legal fees to go after them.
That's right.
Because everyone thinks they're like, well, you can't knock me off because I have a patent. Yes, I can.
Yes, you can.
And now you have to fight me on it.
And I won't even talk about international patents because your U.S. patent doesn't protect you outside of the continental U.S., period.
So now
people think I have a U.S. patent and they can't do that in Europe.
Europe is better at respecting U.S. patents, but a lot of Asia just doesn't care.
They don't at all.
At all. In fact, that's
they're looking.
They're looking the patent office
so they can.
And this is something that people also don't understand. So, you got to get this manufactured. It's hard to do manufacturing in the States because it's very expensive.
And then you're going to take it overseas.
And so you take it overseas or you go south, you go to Central America. Yeah. So those people now have your information. And there are many examples of where they took your idea and they came back with like crappy prototypes or high quotes. And you're like, well, I'm not going to do that. And then all of a sudden it's, being shipped overseas to the U.S. You're like, well, that's my idea. And you try and fight it.
No,
good luck.
And the thing about that is if you do have a patent and they ship it in, they can enforce to say, hey, look, we're stopping all shipments of this now. You can't ship it into us because we have a patent. So that's one nice thing. If you do have some stuff and someone overseas knocks it off, you can, if you
can prove it.
If you have enough money in your pocket to stop them. And by the time you stop them, your 20-year patent might be over. So there's no protection anyways. So patents, I still think are a good thing. I encourage people to go down that road.
I don't most of the time.
But at the same time, I also say, look, you need to understand the risks that go with it because there's a lot of misunderstanding about patents and patent pending.
I am going to argue that for most small businesses, patents are a little bit bigger than what they're able to do. That doesn't mean don't educate yourself.
Yeah.
Get the correct advice. Look at your unique situation. But patents are complicated. And so going into a situation where you're not, you don't have the capital to create it, protect it, Or you really don't have any unique R&D. Like there are so many times, and that doesn't mean that don't pursue your idea. There's nothing wrong. I've got some really cool stuff out there that is not protected that, I consulted with some advisors and they told me, they're like, well, you really can't protect this as much as you think you can. And so I still put it out there. I still wanted it in the market.
I run into, and it's not a high number, but occasionally someone just is frustrated about a patent or infringement and what to do. I just like, look, it just comes down to money. It's all about the Benjamins. And so if you have deep pockets, you can probably do something about it. Occasionally you might find an attorney who sees that there's something legitimate if you, with your one free hour of consultation that maybe they'll do it. But a lot of times attorneys, unless you have a really strong case, they don't want to touch it because it's just... Anyways.
Okay, this is where I want to put a caution out there for small businesses. We're talking about the deep pockets, and a lot of small businesses don't have the deep pockets, and there are some pretty unethical attorneys. I'm not bashing on attorneys here, but I'm saying just like in any industry, right? They're unethical taxi drivers. Like I'm not trying to pick on an industry, but I'm saying that you've got attorneys that literally will just scour for infringements of any kind.
That's right.
They'll be looking for patent infringements, trademark infringements, copyright infringements, made in USA claims that are false, ADA non-compliance. They don't care, right? And they're looking for it, and they're targeting. And I'll tell you, if you are a small to medium business, you are actually the prime target of this type of activity. Why? Because you're big enough to pay something, but not big enough to have a team of attorneys. Yeah. And one of the tricks that they'll use is they'll cross state borders. And people, like, if I get a complaint against me from someone in New Jersey, I have to follow New Jersey law, which means I might have to present myself in New Jersey to fight that. And so I'm like, oh, okay, now I'm going to take my attorney and I'm going to fly them to New Jersey and pay their per diem on top of their, and you just get buried. And these attorneys know that. And so honestly, and again, this is the minority. This is not widespread. But if I'm a small business and I am, I'm manufacturing stuff, like manufacturing. So we just did an episode on Impact Utah. And I'm going to go back to, if I'm a small business and I'm in a manufacturing space, I'm very vulnerable. Reach out to whatever organization is in your area. There's a lot of state organizations that will give you some great counsel on how to protect yourself from, make yourself not vulnerable to these types of attacks.
Yeah. So in wrapping up, that's just kind of a real brief about the big three and arguably a fourth with trademarks.
Trade secrets.
Sorry. Thank you. So here's your trivia for the day. Because this one is not really known, but it's fun to hear and know about this one.
I pretend to be a know-it-all, so I'll make up something that'll be believable.
There's a number of other categories in IP. However, how about this one? Plant breeders' rights. That is a legitimate right that's protected. That is if I'm working with plants and I'm cross-pollinating and producing and creating things like that, and along with if I can find sustainable ways to grow and make crops more productive.
Have you ever played the game Balderdash?
A long time ago. So I just put that out there because I've heard about it before, and I read about it recently as I was brushing up on this one. I thought, yeah, that's fascinating. I've never, and it's kind of interesting. If you live in a rural area, there's always agriculture around at some level. And it makes me wonder if some of that's going on behind the scenes that I would never know just because, well, I'm sure there is because, when you get into Colorado and some of the other states, that marijuana and some other things are now becoming legalized, and they're trying to control it. I bet there's some plant breeder rights in there, and how they do it and how they, can distribute. And anyways, I wouldn't be surprised if there's something tied to that.
Yeah,
so, well, that's all I got.
So this is going to be my closing remarks, my closing thoughts. I feel like maybe some people would listen to this and be like, screw it. I'm not doing any business. It's too complicated, not worth it. I'm going to say this. Anything that's worth doing is going to have some hurdles and some obstacles. Yeah. If it doesn't, then everyone's going to do it. And it's kind of like fidget spinners, right? Fidget spinners were so cool for about 3 months. and so if your business doesn't have some barriers to entry, if it doesn't have some hurdles, it's probably not a legit long-term business. You're not going to see long-term profits off of it. And so I know that it can be frustrating to be like, oh, here's one more layer that I now have to deal with, one more element of risk. And I'm going to say, okay, yes, but as you get past some of these hurdles, you start to put some barriers to entry up for other competitors. And so this really can be an area of competitive advantage. And, and I would say entrepreneurs need to take some risk. So don't be afraid to, if it's not on the table to get a patent, put your product out there anyway. I've seen some people, market. Yeah, I've seen some people that have held on to stuff for decades. I'm like, why? What did you get over those decades? Nothing. So, at least try.
Yeah, my argument is always, if you're going through any one of these processes and you have some legitimate product and it's going to go somewhere, be first to market and flood the market. It makes it hard for anybody else to now enter.
Yeah, and you can win that way too. So don't just give up because you're like, oh, I don't have the deep pockets to push this. And I'm like, well, yeah, first mover advantage, push that. Look for other ways. Maybe partner with someone who does have the pockets. Do some licensing, and so there are options.
There are.
So anyway. Thank you so much for joining us today. That is an episode of LearnBiz. If you enjoy this content, go ahead and check us out. We've got our YouTube channel. We've got all of our content on the learning platform, jazzjune.com. And you can reach out to us, Ryan or Ethan, at learnbiz.co.
Thanks, everybody.